Hello, I'm Julie and I'm going to guide you through our presentation on the Renters' Rights Bill 2024. I hope you find the information useful. So here we go. How did we get here? So you may remember back in August 22 we spoke to you about the Renters Reform Bill. This bill made its way almost through the parliamentary process, but not quite. And it didn't make it before Parliament was dissolved ahead of the general election in 2024. So we had a change of government in July 2024, and Labour's manifesto promised to continue with the previous reforms, which included the usual headline of the abolition of no-fault evictions. So we now have the Renters' Rights Bill of 2024, which is the same in many ways, but different in some of its detail. So what will be changing? Our tenancies will change. We will no longer have assured short hold tenancies, but we will have assured tenancies in their place. Now, currently tenants are entitled to a statement of terms and conditions of their contract, and we'll look at some changes around this area. There will be the introduction of some changes around discrimination, particularly around applicants in receipt of benefits and families with children. Pets, so lets and pets. It will continue to be okay to advertise your property that you don't want pets, but we'll learn that with existing tenancies there are changes as to what happens when a tenant asks if they can have a pet. We'll see the introduction of a private rented sector database, which will list all landlords and properties, and of course it will become an offence to advertise without an active entry on this database. We'll see the introduction of a redress scheme, where once again it will be a requirement for all landlords to join the scheme. There was changes around payment of rent, particularly advanced rent, lump sum advanced rent, and there are changes to the rent increase process as well. Legislation will bring in the Decent Home Standard. The Writers' Rents Bill will insert a new section into the Housing Act 2004, which deals with property condition. There are changes in which we go about regaining possession of your property, if that is needed. Once Section 21s are gone, Section 8 will be the only notice available for possession. We'll see the introduction of a number of offences, and we'll look at the penalties attached to those offences. So first of all, tenancies. So we'll no longer have assured short hold tenancies. This is because a section of the Housing Act is being removed, which includes the removal of Section 21 of the Act, which of course is the name of the notice. We'll end up with what's likely to become known as periodic assured tenancies. Now, the main difference between assured tenancies and assured short hold tenancies is that assured tenancies are lifelong agreements that will only end if the tenant chooses to leave or if they are evicted. Assured tenancies hold much more security of tenure for tenants over the assured short hold tenancies that we know very well at the moment. There will no longer be any fixed terms in a tenancy. They will be periodic at all times. The period of tenancies will be no longer than 1 month. They can be shorter, but definitely not longer. And it will become an offence to try and do anything other than offer a tenancy period of 1 month. This piece of legislation overrides any clauses you may have in a current mortgage contract. Those that have mortgages, you may well know that often your lender will ask for a fixed term tenancy of 6 or 12 months, but this legislation will override those conditions in your mortgage agreement. So moving on to the statement of terms and conditions. So under current legislation, a tenant is entitled to a statement of the terms and conditions of their tenancy. An assured short-haul tenancy contains all the details of a statement, but if you have a verbal agreement with your tenant, or perhaps a verbal agreement with a friend, family member to live in the property, it's important that you're aware that these statement of terms and conditions exist, and that currently, like I say, if the tenant asks for one, they're entitled to have one. But in the future, all tenants must be given a statement whether they ask for one or not. And it will become a requirement to provide such a statement before a tenancy is entered into. Now, the content of the statement will be prescribed by regulations. These regulations haven't been written yet, but when they are, they will give us the content of what's to go in your statement. Of course, the statement can be built into the tenancy agreement, and this will be our approach. So it's very much expected that the content of a statement will include the name of the landlord, the name of the tenant, the property address, and the rights and obligations of all the parties. We'll move on now to talk about the discrimination part of the new legislation. You see, we already know it's unlawful to advertise no DSS. But why? Because claiming benefits isn't a protected characteristic under the Equalities Act of 2010. However, a successful court case ruled that as there are more single mothers claiming benefits, and that's because they usually have the childcare responsibilities, that such a policy adversely affects women and therefore constitutes sex discrimination. So what's happening here is it moves this court decision into law. It won't affect really anything we do because we've already been aware of this, but it's just important that we explain to you why. We also are not going to be able to advertise no children. We can't discriminate against people just because they have children, unless there is a legitimate aim. So what's a legitimate aim? Well, it might be, let's say you have a property in a building that is restricted to only occupiers over the age of 55. So quite clearly, you can't have children in a building where you can only have over 55s residing. It might also apply where you've got a small studio apartment. It's not suitable for an adult and a child. It would be overcrowding, so that would come into that legitimate aim. Let's quickly move on to pets. So first of all, what is the definition of a pet as far as this legislation goes? Well, it's an animal kept for personal interest, companionship, ornamental purposes, or a combination of the above. We already know that there are situations where a landlord cannot restrict an occupier having an animal. Under anti-discrimination laws, a tenant who has a recognised disability can bring an assistance dog into the property, would be a guide dog for example, and assistance dogs are not viewed as pets. So it will continue that if there is no offence in advertising no pets, unlike the children and benefits we just spoke about previously. But a landlord can only be reasonable if refusing permission for pets, applying the situation to an existing tenant. So how does the process work? Well, your tenant requests in writing stating what pet they'd like. Now you may need to ask for further information. If so, you can do that, or you provide a response within 28 days. If you do request further information, then that timeline of 28 days is suspended until you receive your further information. But upon receipt of your information, a response must then be provided within the next 7 days. If you require the permission of a freeholder, then you should seek that consent within the first 28 days. Again, the timeline is suspended whilst you await for the response. But once you receive the response from your freeholder, you then must have to give your decision within the next 7 days. If you have a property in a block, quite often we'll find that the head lease will say there are no pets to be allowed to live in the building. And if that's the case, that's fine. We won't worry about it any further. And we just need to let your tenants know. They should already have had a copy of the head lease, but we just need to let your tenants know. Now, it's worth knowing that pet damage insurance will become an option for landlords. So they can then insist that tenants take out insurance cover to cover any damage by the pet. Or you can request that the tenant pays the landlord's insurance premium. The requirement to have insurance must be in writing at the time consent is given. So what we're saying there is that at the time you say, okay, you can have a pet, you then must let them know that they need to have pet damage insurance or to pay the premium of a policy which you as a landlord hold. Until this legislation takes effect, it's not possible to charge the tenant for pet damage insurance. The Tenant Fees Act restricts us from doing that. But the new legislation will bring an amendment to the Tenancy Fees Act to make the premium a permitted payment. The requirement to pay can also include an excess of the policy. So again, you shouldn't be out of pocket in this situation. So now let's look at the private rented sector database. Landlords will be required to have an active entry on the database from the time the property is advertised until after any letting finishes. Landlords and tenants will be listed on the database, and the database must be kept up to date as required. We expect this to be with each gas safety record, each EICR and each EPC. The database will also provide a unique identifier for every landlord and property, and it will become an offence for us as an agent to let a property which is not on the database. So we will ask for that unique identifier number from you. This database is about ensuring compliance with standards, which is why we expect that each of those compliance certificates have to be added. All in all, should be a good thing. The database will hold any details of penalties and banning orders against landlords. If a landlord is not on the database, then they cannot seek possession of their property, with the exception of antisocial behaviour, and it's understandable why that is the case. There will be heavy penalties for non-compliance. Now, the public will have limited access to the information. We think it really will be very limited, but it will enable them, most likely, to be able to view which properties are up to date with compliance and therefore in good order, hopefully. There will be greater access for local authorities, and that's understandable because they're the ones that are going to be given the power to make sure everybody is compliant. There will be a fee payable to join this database, and we'll let you know as soon as we know what that is. The penalty for not having an active entry on this database or not displaying the unique identifier when advertising could be up to £7,000 for a first offence and up to £40,000 for knowingly or recklessly providing false information. The Landlord's Redress Scheme, so a different scheme, but will still be something that all landlords have to join. And landlords will need to be a member before marketing a property and remain as a member for a period after the let. This period is yet to be determined. We think, we don't know, but we think it may be for up to 6 years after the end of a tenancy. And this will allow the redress scheme to deal with not only potential and actual tenants, but also past tenants. Using an agent does not exempt a landlord from the scheme. Agents are already required to join an agent's redress scheme, where members of the property ombudsman. And redress schemes are there to look at processes and the intention that the members keep to their obligations. Now, an agent's obligations can differ to those of a landlord's. For example, it's not the obligation of the agent to carry out a repair. It's the landlord's obligation, and we know that because it says it in the Landlord and Tenant Act of 1985. So, if a landlord refuses to carry out a repair, then ultimately there's nothing the agent can do. And if a tenant were to complain, then the redress scheme would not penalise the agent in such a situation, because providing they've met all their obligations, they've done nothing wrong. This new redress scheme for landlords would mean that, yes, a landlord could be penalised for not meeting their obligations around repairs. In such a situation, these redress penalties can be treated as a court order if the tenant wanted to enforce it, which might then go on for the court to force a landlord to carry out the repair, something called specific performance. So now let's look at rent and some changes that the Renters' Rights Bill makes around the payment of rent, particularly lump sum rent in advance. This will now become prohibited. So if we go back to thinking that the period of a tenancy can be no more than 1 month, then the rent requested can be no longer than a month. So periods of the tenancy must match the periods for which rent is payable. That's how it's written in the legislation. So we can no longer have lump sum rent in advance. We're used to calling it 6 months rent upfront or in advance. It has been used in the past where applicants' references are insufficient, particularly financially. Somebody who's recently self-employed or new to the UK perhaps wouldn't have evidence of an income that would support their application. And often these people will have savings and they would offer to pay rent in advance. But it means that we're not going to be able to do this anymore. I guess this makes the importance of quality tenant selection even more important from the beginning. So we're working hard to see how referencing processes can be improved, if at all. With regard to rent, the price of rent quoted on advertising will also set a ceiling on what can be charged. So you could accept an offer that is lower, but not a higher one. So rent increases. So we'll no longer have rent increase clauses in a tenancy agreement. Taylor Scott agreements have always had rent review clauses. It's a simple and straightforward way of doing it. No longer lawful to simply negotiate a rent increase either. All rent increases will need to use the Section 13 process. So Section 13 is a part of the Housing Act that deals with rent increases. We won't be able to use the Section 13 notice within the first 12 months of a tenancy. And the notice period we need to provide will be increased to 2 months. So currently is 1 month, it's going to be increased to 2. That's fine, we'll just make a note to serve the notice earlier than we previously do to just keep the dates in the same cycle. Section 13 notices are prescribed for forms. So this is important because it's the legislation that decides what they say and how they look. Anyone who's using our full management service or our rent managed service, you haven't any need to worry about this. We'll take care of it for you. For those that are doing your own rent increases, just be aware that there are notes on the reverse of these forms which explain to the tenant how they can appeal a rent increase. Now, an appeal is made to the first tier tribunal, and there's no cost to the tenant of making an appeal. They don't need a specific form. It's simpler than ever for the tenant to appeal. There's also no risk to the tenant in appealing. The first tier tribunal can only set the rent to the lower of either the open market rent or the figure which you've set out in the Section 13 notice. So the tenant has their notice, they've got a figure on there, and they know that the tribunal has to go with either that figure or the open market rent figure if that's lower. They're never going to be given a higher figure than that. They've kind of got nothing to lose. So it's worth knowing that if an appeal happens, that hearings, I believe right now, are taking 4 to 6 months to be heard. And this is against a backdrop of a small amount of notices being used, never mind appealed. Rent increases would be effective from the tribunal hearing date, not the date on the notice. So effectively is delayed by around 4 to 6 months. So when the tribunal hear the case, they make their decision, they don't backdate it to the date on the notice. It starts from the rent next due after the hearing date. So like we say, 4 to 6 months, you might have to wait for that. Let's move on and have a look at the Decent Home Standard. So currently the Decent Home Standard only applies for social housing and involves complying with basic minimum standards. So this legislation doesn't set standards, it just ensures compliance with other legislation. So minimum standards that are already set out in other legislation. So the property should be in a reasonable state of repair. There should be reasonably modern facilities and services and reasonable thermal comfort. This one relates to the EPC standards. So we know that a property has to reach a minimum of a band E on the EPC to be put onto the lettings market. We are aware that there are plans to look at raising that minimum standard to a C banding by 2030. That's a whole other issue. Perhaps we will come back to you and talk to you about that when we know exactly what's going to be happening. It is quite a way away at the moment, but the way time flies, I'm sure it'll seem no time at all before we're back in touch with you. So back to the Decent Home Standards. So these new regulations will be introduced under the Housing Act 2004. They deal with property condition under the Housing Health and Safety Rating System. And they'll cover the state of repair, the things that are to be provided for use, safety, security or comfort, and keeping the property at a suitable temperature, or being able to keep the property at a suitable temperature is perhaps more accurate. We expect to see the introduction of Type 1 and Type 2 requirements, either alongside or to replace the existing Category 1 and 2 hazards. Further clarification is needed, so it'll be interesting to see how these are written in the regulations once those are indeed written. So we'll move on now to Awaab's Law. So I'm sure you will have heard about Awaab's Law previously. Awaab Ishaq was a two-year-old boy who died from respiratory issues after living in a damp property riddled with mould. In Awaab's case, the landlord was Rochdale Borough-wide Housing, and they had not visited the property to check the problems which had been reported, and merely told the tenants to paint over the mould. But quite naturally, such a response was criticised, and hence the new guidance which came out, and the Awaab's Law, which we will see introduced into the private rented sector. At the heart of the legislation is the presumption that it is for the landlord/agent to take action when a repairing issue is reported. So a new section of the Landlord and Tenant Act 1985, which deals with repairs and maintenance, will be drafted within the new regulations, but we believe the proposals are that a landlord must investigate within 14 days, and landlords must take action within 7 days if a medical professional decides there is a health risk. Possession, so changes to the way we gain possession of properties. Section 21 notices will be abolished. We know this because we're going to see the removal of a big chunk of the Housing Act, sections 19A to 23. They will be removed, put in the bin. We have to remember that notices are a notice of an intention to apply for possession through the court. That's not new. Most tenants, of course, move out on the expiry of a notice, but ultimately possession can only be awarded by a court. Section 8 will become the only notice available for possession. So if you find yourself in a situation where a tenant hasn't left on expiry of the notice, then it will be necessary to apply and go to a court hearing. Section 21 was different. The judge had to award possession there. There was no court hearing needed. It was very much supposed to be anyway, a quicker procedure, and held the name accelerated possession proceedings. But we have to remember that now each Section 8 notice will require a court hearing. Now, a reason will need to be given when giving notice for possession, and you do this by using one or more of the grounds for possession. Grounds are reasons, that's all. There are currently a total of 21 grounds, separated into 10 mandatory, where if proved possession must be awarded, and 11 discretionary grounds, where a judge can award possession if it's deemed fair. New grounds have been added to the ones we already have, and we'll just look at those now. So ground 1 has been amended, in fact, and this is if the landlord wants the property for themselves or a specified family member, and there's the list of specified family members. The notice will be 4 months long, and it cannot be issued within the first 12 months of a tenancy. And there will be restrictions on any further lettings following the 12 months, for the following 12 months, should I say. So if you give your tenant notice, they move out, for the next 12 months you really cannot bring the property back to the lettings market. You've said you want it to live in, and that's what you must do. We'll see a new ground added, and this is to seek possession if you want to sell your property. Again, the notice will be 4 months long, and you cannot bring this property back to the lettings market for the 12 months following the expiry of the notice. So you've got to be committed to selling the property, and you must be aware that if it's taking longer than you'd hoped to sell, you cannot quickly bring it back to the lettings market. And possession for rent arrears. Now that's always been there. Ground 8 has always been the serious rent arrears ground. It has been amended. So the tenant will now need to be 3 months in rent arrears, and we would be required to give them 4 weeks notice. So at the moment they have to owe 2 months of rent, and the notice we give them would be 14 days long. Under the new legislation, the tenants will owe 3 months of rent, and the notice they're receiving is 4 weeks long. So you can see it's going to take longer. If the rent arrears, of course, aren't brought up to date, you may need to approach the court, and a court hearing will be required to regain possession, and then we must expect a lengthy delay. This could possibly be 4 to 6 months to wait for the hearing. If necessary, there could be a further wait for a bailiff. This is all worst case scenario, of course. The total wait could realistically be a year. So it's going to be really important just to know that if you cannot afford to be without rent for, say, up to a year, then you definitely should consider what I've worded there as rent guarantee insurance, but I think the better term is rent and legal protection. It's really important that you at least give it a consideration, because it would cover you. So for a small premium, it would cover you for the loss of rent, the cost of the legal process in regaining possession of your property, and all the while you're going to be receiving money from that policy to cover your lost rent. So we'll look now at tenant notice. So a tenant's notice can be given any time, but it must be 2 months long. So it's been increased from what we've come to know, 1 month's notice to 2 months' notice. A shorter notice can be negotiated in the tenant's favour, but not in the landlord's favour. Notices must be in writing. They can be in any written form: email, letter, text, even social media, but they should be in writing. Have a look now at offences. So it will be an offence to issue a fixed term tenancy, use a notice to quit, so this is a notice from the landlord to end a tenancy, Remember, the only way we can end a tenancy now is using those Section 8 notices. To end a tenancy orally or verbally, or even to require it to be brought to an end orally. And it become an offence to use grounds for possession without the belief you have the right to do so. So there are a significant number of offences there, and a whole load of other offences you could fall into. We won't spend any more time on them. It's just important you know that they're there, but of course we prefer to focus on explaining how to do it right to avoid an offence penalty. Penalties, as I have mentioned earlier, there will be a new standard penalty. It seems to be up to £7,000 civil penalty, which will be issued by the local authority. The money therefore is kept by the local authority to help fund enforcement of all these regulations. These penalties can be escalated up to £40,000 for repeat offenders or an ongoing offence. Rent repayment orders and banning orders are possible further offences, and both of those are quite disastrous for a landlord and an agent, so we don't want to be going there. So when is all this likely to happen? Well, the latest was on the 4th of February. There was a debate in the House of Lords, and we've now moved on to the committee stage of the House of Lords. Once we get there, there will be royal assent, and once that's all signed off by King Charles, we will be given a number of months' notice of implementation. All of this legislation, I understand, is going to come in all at once, and in the industry this is being called a Big Bang date. So if you hear of a Big Bang date, then you'll know what we're talking about. So that's the end of the presentation. If you do have questions, please do get in touch with us. You can email us, you can telephone us. Please do. We'd welcome your questions. We want you to feel comfortable. So I hope you found the presentation informative, and we hope to be in touch with you soon with updates. But don't forget, please do let us know if you have any questions. Thank you for your time.